started. Thank you everybody for joining us today. My name is Jiyae Hwang and I am a senior associate at Scott Legal PC. And today we're going to spend some time talking about the various visa options available for individuals with extraordinary ability in their fields. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We are continuing this webinar series, and we are doing at least 2 webinars a week on different immigration law-related topics. And at the end of this webinar, we will be sending out a few resources for the benefit of all participants. First, we will send you a copy of the PowerPoint that will be used in this webinar today. We will also be sending you all a visa guide, a comprehensive guide to the visa categories that we will be introducing today that you can use as a resource. We will also send you a link where you can sign up for the additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button in our channel because we do regularly upload a variety of immigration law related videos that can be helpful to you. We'll also send you a link that you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your case in further detail. So today we're very lucky to have Catherine Perez, who is also a senior associate at the firm and actually a former USCIS adjudicator with a wealth of experience handling cases in the visa categories that we will be speaking about today, who will be presenting about these various options available to extraordinary ability individuals and the requirements and considerations. Finally, for any question you may have, please feel free to add them to the chat box or the Q&A function, and we will try and get to all questions. So without further delay, let us get started.
All right. Thank you, Jiyae, and thank you everyone for joining us. So as Jiyae mentioned, today we're going to discuss the extraordinary ability visa categories. The first ones we have listed here are the O-1A and the O-1B, which are both temporary non-immigrant visas. With these visas, you will have the ability to work in the U.S., but you intend to come here temporarily to fulfill that work. In contrast, the green card option would be for someone who intends to work and live in the U.S. permanently. So again, we first have the O-1A. This is the temporary non-immigrant visa for individuals with extraordinary ability in the sciences, education, business, or athletics. It has a very high standard in which you have to be one of a small percentage who have risen to the top of your field in your profession. We also have the O-1B. This is another temporary non-immigrant visa for people with extraordinary ability, but particularly in the arts. O-1Bs are treated a little bit differently than the O-1A. The standard is slightly lower. So the person must have received distinction, meaning a high level of achievement evidenced by a degree of skill and recognition substantially above that ordinarily encountered. Within the O&B, you also have a subcategory for people with extraordinary ability in the motion picture and television industry. The standard for the motion picture and television industry is a little bit higher. You have to show that you have a record of extraordinary achievement in the motion picture and television industry, such that you have a very high level of accomplishment evidenced by a degree of skill and recognition significantly above that ordinarily encountered, to the extent that the person is recognized as outstanding, notable, or leading in the field. So this is in relation to your peers within the industry. So we'll also talk a little bit about, I think next slide, if that's okay, Jiyae. Thank you. We also talk a little bit about the green card options for people with extraordinary ability. So first we have the EB-1A. This is very similar to the requirements of what you would encounter with the O-1A and the O-1B. But there's not the separate category for the arts. So this category is for those with extraordinary ability in the sciences, arts, education, business, or athletics, and it's all under one umbrella for the EB-1A. Here again, the individual must be one of a small percentage who has risen to the very top of the field of endeavor. So you have sustained national or international acclaim, and your achievements have been recognized by in your field of expertise. So you must remember for this, it is important for the person that is coming to the US to continue to work in that field of extraordinary ability. So if you've had a very successful career, but just want to retire, the EB-1A would not be a good option for you. The government will want to see a statement of proposed intent of what you plan to do in the US, and it does need to be related to your area of extraordinary ability. We also have the EB-2 National Interest Waiver Green Card. This one is not always lumped in directly with the O-1B or the O-1A or the EB-1A, but it is a very good option for people who were maybe on the O-1B and don't quite meet the EB-1A standard yet, but still have an impressive background and are working on an endeavor in the US with substantial merit and national importance. So you may be eligible for the employment-based second preference visa if you are a member of the professions holding an advanced degree or its equivalent, or a person who has exceptional ability. So for the EB-2, you do have to meet the threshold requirement of an advanced degree or exceptional ability in your field. If you're claiming the exceptional ability, you'll need to explain how your area of exceptional ability directly relates to your proposed endeavor. So the term endeavor is more specific than a general occupation. You should be able to offer details not only as to what the occupation normally involves, but what type of work you propose to undertake specifically within the occupation. So for example, if your occupation is engineer, then the explanation of the proposed endeavor should describe the specific projects or goals you might work on as the engineer. You'll also need to provide a detailed description explaining the proposed endeavor and provide supporting documentary evidence to establish that the endeavor is of national importance and has substantial merit. You'll also need to show that you, as an individual, are well positioned to advance this particular endeavor. So there needs to be kind of a nexus between your expertise and your experience and what you're going to work on. It all needs to be connected. And then based on that, you would argue that it's beneficial for you to come to the US and that the US waive the normal labor certification requirements that would require the US employer in a labor market test. And that you should not have to go through that because what you're working on is so important that it would be beneficial to have you here in the United States. One very important thing about both the EB-1A and the EB-2 National Interest Waiver is that you can self-petition. This is a little bit more flexible than what you would encounter with the O-1A or O-1B. For those visas, which are temporary, you would need either a U.S. employer, an agent, a U.S. agent, or an agent operating for a foreign employer. Okay, so we can go to the next slide. So now we will look at what you need to demonstrate for the O-1A. So you can show that you've won a major internationally recognized award, something like a Nobel Prize or a Pulitzer Prize, but much more commonly, you're going to probably fall in a category with most others where you're going to show that you meet at least 3 out of the following criteria. So 3 is the minimum, but you would want to show more if possible. So first, we have the receipt of nationally or internationally recognized prizes or awards. You would want to consider when looking at the prize. Is it national, the whole nation? Is it international, more than one country? So prize is something offered or striven for in competitions and contests. An award is something that's usually conferred upon you, bestowed based on merit. So things to consider would be the criteria for winning the prize, past honorees, the number of prizes or awards given each year, limitations on the eligible competitors. You'd want to think about were these awards you received while you were in school as a student? Was it something at university or college? If so, it's really weighing the evidence and the type of competition in the award. Because if it's something not as prestigious, it may not be very compelling. So for these petitions, it is important to look at everything holistically. You want to put your best foot forward for the officer to look at the evidence and really determine that you've risen to the top of your field. So including things like a student award from a university could start to lower the profile or maybe make it look like you're not as of extraordinary ability as you claim. So in contrast, if you were at a university and won a very prestigious award where other professionals in the field also competed, you could and would want to include this within the filing to show. Okay, we also have membership and associations in your field, which require outstanding achievements. So here you would want a membership that actually requires you to have some outstanding achievement in order to be invited or in order to apply to become a member of that association. So it is important to look at what are the requirements to become a member. So can anybody enter? Does it actually require outstanding achievements? Factors that might suggest membership is not based on outstanding achievements include, is the membership based on a level of education? Is it based on payment for a fee? Something like the Bar Association for a lawyer would not work. So anyone who's passed the bar can join by paying a fee. It does not require outstanding achievements in the field to become a member of the bar. And we also have published materials in professional or major trade publications or major media about you or your work or something you're working on. So here the article and the information should be about you, but the publication could cover a broader topic and include a substantial discussion about you and your work and mentions you in connection with the work. So we also have original scientific, scholarly, or business-related contributions of major significance. An original contribution could be something like a patent or processes. It's important to show how the work has already impacted the field with this criterion. Potential impact is not sufficient for this. Oftentimes, people commonly provide testimonials about your work, and the testimonials will provide the potential impact of the work. So this is not sufficient. The testimonials should explain in detail how the work is already of a major significance on the field. So we also have authorship of scholarly articles in professional journals of major media in the field. So this can include publications in professionally relevant journals or published conference presentations at nationally or internationally recognized conferences. This criterion I often saw come up with those involved in academics, but it could apply to other fields as well. We also have a high salary of remuneration for services as evidenced by contracts or other reliable evidence. So again, here you're going to be looking at what is your field of extraordinary ability? Where are you working? And are you going to be earning a high salary in relation to others in that field? So you can show this by comparing your salary to labor statistics. But I would say recommend make sure you compare apples to apples. If you're giving an hourly wage, then make sure you're comparing it to an hourly wage, not the annual wage. So we also have participation on a panel as a judge of work of others. Here you must show that you've participated as a judge of the work of others in your same or allied field. An example of this could include reviewing abstracts or papers submitted for presentation at scholarly conferences, or serving as a peer reviewer of scholarly publications. So you might document your peer review by submitting a copy of the requests from the journal to you for the review, and then accompanying it with evidence showing that you completed the review. We also have employment in a critical or essential capacity for organizations with a distinguished reputation. So here you would want to explain your role within the organization and detail how it was critical or essential. Critical is that you've contributed in some way that is of significant importance to the organization or the establishment's activities. Essential was your role integral to the entity. So generally, like a leadership role in the organization qualifies as critical or essential. You would also still need to show that the organization is distinguished. So if you are a CEO of a very small company, you could likely show that you had a critical or essential role, but maybe the company is not distinguished. So you wouldn't be able to show this criterion. Conversely, if you work for a company like Apple, this is a well-known distinguished company, but if you worked in the factory boxing up the iPhones along with hundreds of other workers, you have this distinguished organization, but your role within the organization probably wouldn't rise to critical or essential. Okay. We also have, let's now look at the O-1B requirements. So again, this category is for the arts and those in the motion picture and television industry. The O1B has a similar structure to what you would encounter with the O1A in the sense that you're going to qualify by either one significant award, like a Grammy, and you would need to, or you can satisfy 3 out of the 6 criteria that we're going to discuss on the next couple of slides. So the first criterion we'll discuss is having been and will perform as a lead or starring participant in a production or an event with a distinguished reputation. So evidence may include demonstrating a lead role by establishing that your role was a principal role in the event or production. A starring role could be a position of great prominence relative to others in the production. So generally with this criterion, the difficulty comes with the future elements. It can be really hard to show that a production will have a distinguished reputation in some cases because there may not be critical reviews or advertisements yet. So that was always the difficulty I saw people encounter when I was adjudicating these types of cases. So we also have critical reviews of other published materials in professional or major media by or about the beneficiary. So here I often saw the difficulty could come showing the media is major. So the government doesn't hold much weight to articles that you can self-publish or that are not vetted versus an article in the New York Times. So you must provide evidence that demonstrates it is major media or professional or journals published materials. So sometimes that was always difficult for people to demonstrate. You must provide evidence that demonstrates the beneficiary was recognized for achievements or awards. So that's always important to make sure the media you're submitting demonstrates that. We also have evidence that the beneficiary has performed and will perform in a lead or starring or critical role for organizations or establishments with the distinguished reputation. So here it's important to remember that it is a critical role for the organization, not just an event or that the organization puts on. So that would be for the first bullet point. So oftentimes people conflate these two criterions, but they are separate. You should really consider the role maybe within the organization versus the role within an event or production. So for example, did you perform as an actor in a movie or did you perform as the CEO of a movie studio? Was the role permanent or temporary? So you should really kind of look at your role within the organization holistically and whether or not it was like an event or production. We also have evidence of a record of major commercial or critically acclaimed successes in the performing arts. So this is shown by box office receipts or record, cassette, compact disc, or video sales. So as you can see, this criterion does have some outdated evidence requirements on it. For instance, I don't think anyone sells cassettes anymore. So for this criterion, you might have to be a little bit more creative. For example, with the commercial success, you may not have record sales, but you may be on YouTube. And if you're on YouTube, do you earn money? How much? Can you show commercial success monetarily from your YouTube channel? And like, is it high compared to others? That would be something you could show. If showing or demonstrating critically acclaimed success, the evidence should demonstrate that the beneficiary's work has received public-facing praise, so positive reviews in your field from the professional art, television, film critics, something like that. We also have evidence of significant recognition for achievements from organizations, government agencies, or other recognized experts in the field. This can come in the form of a testimonial. That was always the most common piece of evidence we would see for this criterion. But it should really, if you're using a testimonial, you really should focus on what is the achievement. So if you're speaking to someone's potential and mention they are a hard worker, this is not sufficient. The details on the achievement are important. Again, we have the evidence of commanding a high salary or other significantly high remuneration for services in relation to others. Again, you can show this by comparing your salary to the labor statistics. But also, I always recommend that you show an equal comparison. So if you're giving the hourly wage, again, you'd want to compare it to an hourly wage on the labor statistics. Otherwise, the officers reviewing the evidence will just indicate it's not a sufficient or equal comparison. We also have other comparable evidence. So that's to say, if you're applying for an O-1B in a very um, odd or unique field, and you feel that the previously discussed criterions do not apply to you, you would need to explain why they do not apply to you. Um, and then the evidence, then also explain why the evidence you are providing is comparable to the regulations, the criteria is listed in the regulation. So this is actually a really big hurdle to meet, but it's something you can consider. In the time I did adjudicate the cases with USCIS, I never saw anyone provide um, the sufficient comparable evidence that we would actually rely on the comparable evidence and say, oh, yes, the previous criterions do not apply to your field. So it is a really, really high hurdle to overcome. Then just as a note, the other comparable evidence is not available to those in the motion picture industry. Okay, so we'll go over the charts and the important similarities and differences in the O-1A and the O-1B. So again, the fields in the O-1A, we have the sciences, education, business, or athletics. The O-1B, you have the arts and motion picture television industry. Sorry. The standard for the O-1A is one of the small percentage who has risen to the very top of their field. Again, this is a very high standard to meet. You also have the arts, which is a high level of achievement as evidenced by a degree of skill and recognition substantially above that ordinarily encountered. Yeah, for the motion picture television industry, this would be a level of acclaim substantially above that or his or her peers. So one thing I would mention if you're considering if your field is somewhat fluid and perhaps you could land in an O-1A or an O-1B, you might want to pick the O-1B just because the standard is a little bit lower. So the visas can be issued for 3 years. You can extend them for 1 to 3 years. This would depend on the type of work you're indicating that you're going to continue. So is it new work, which would be evidenced by a new contract, new employer? You could possibly get another 3 years. But is it the same project? Are you considering or just continuing the same position, same employer? In that case, it might only be approved for a year. It just depends on the type of work you're submitting to show that you're going to continue to do. So can your family come to the US with you? Yes. Your family can come with you. This would include your spouse and any unmarried children under the age of 21. They can attend school in the US, but unfortunately, the spouse does not gain the work authorization. So if your spouse is going to work or need to work in the US, they would need to obtain a different type of visa that would allow them to work. Okay. So we'll also go over the EB-1A requirements. This is very similar to the O-1A and the O-1B, but some of the language is a little bit different because it incorporates the arts, sciences, education, business, and athletics all together. So again, the structure is similar where you can qualify with one major award. However, most people will qualify based on showing they meet at least 3 out of the 10 criterions listed in the regulations. So these criteria are really the same and or really similar to what we described in the previous slides. So again, we have them listed here. I can briefly just go over them quickly. But evidence of your membership in an association in the field which demand outstanding achievements of their members, evidence of published materials about you in a professional or major trade publication or other major media, evidence that you've been asked to judge the work of others individually on a panel of, and then we have evidence of your original scientific, scholarly, artistic, athletic, or business-related contributions of major significance in the field, evidence of your authorship of scholarly articles in professional or major trade publications or other major media, evidence that your work has been displayed at artistic exhibitions or showcases, evidence that your performance of a leading or critical role in a distinguished organization, evidence that you've commanded a high salary or other significantly high remuneration in relation to others in the field, evidence of your commercial success in the performing arts, or evidence of receipt of lesser nationally or internationally recognized prizes or awards for excellence. So you'll also need to show here that the person seeking to enter the US is going to continue to work in that area of extraordinary ability. The person's entry to the US will substantially benefit the US in the future. So you can, okay, thank you. So the government adjudicates extraordinary ability visas with 2 steps. The first step would always be to examine the evidence and determine, do they have this major award, international recognized award, like we mentioned with like the Pulitzer, or whether or not they meet at least 3 of the EB-1A criteria explained above. However, simply meeting the EB-1A criteria will not be sufficient just to establish that you get the green card. So the second step of the analysis would be that USCIS will look at the petition holistically. They'll consider the quality of the evidence in totality to make the final determination whether or not you've really risen to the top of your field, and that you are one of a very small percentage of people at the top of your field. So because the second step is really important, that's when the officer would look at your petition holistically, kind of look at everything together to determine whether you've risen to the top of your field. It is important to consider the type of evidence you're going to put in as supporting evidence for your petition. If you throw everything in them at the petition, you want to consider, is this really lowering the profile, or is it raising it? Okay. So now we are actually going to switch to Jiyae, who will be going over the NIW requirements.
All right. Thank you, Katie, for all of the insights. So yeah, now let's shift gears a little bit and talk about the EB-2 NIW as a category for the green card that allows self-petitioning that could have considerable overlap with, you know, the type of client profile that we see for extraordinary ability petitions. However, the requirements are quite different, and yeah, different types of profiles will suit better in either category. So let's go over what it takes to apply for an EB-2 NIW green card pathway. So with regards to the requirement, the first thing to ask is, do you meet the EB-2 threshold criteria? So to actually apply under the EB-2 category, and either if it is an NIW case or just in general, the EB-2 employer-sponsored case, you do need to show that you meet the threshold requirement. And this can be shown by either of the 2 aspects here. You can either show that you have an advanced degree defined as a master's degree or higher, including, you know, degrees like an MBA, for example, a Master of Science, Master of Arts, or a PhD, for example, or the equivalent of an advanced degree. And equivalent of a master's degree, for example, is a bachelor's degree in your field, and you can show that you have 5 or more years of full-time post-baccalaureate progressive work experience in the profession, and that will be considered the equivalent of a master's degree. It is important to note that the degree and the experience must be related, and all of that must also relate to your proposed endeavor in order to work for the EB-2 NIW. And when you are trying to meet the threshold through showing that you have the equivalent of a master's degree, you need to make sure that you have sufficient evidence regarding not only that you have 5 years of full-time work experience, but that your job duties and responsibilities have changed over time, increased over time in complexity and seniority, to show that your work experience was indeed progressive. The government will expect to see a change, an upward change in your work experience, and you must have, you know, the appropriate employment confirmation letters to prove that in sufficient detail. The other way to prove the EB-2 threshold is by showing that you have exceptional ability in the sciences, arts, or business. And if you're going that route, you're not required to show that you have an advanced degree or its equivalent, but you do need to show that you can provide evidence of at least 3 out of the 7 criteria listed here. And the totality of the evidence must show that you are someone with a level of skill that is significantly above what is ordinarily encountered. So there is also sort of a two-step analysis that goes on here. And let's briefly look at the 7 criteria. And here, I think it is important to note that exceptional ability is very different from extraordinary ability that we spoke of in the EB-1A and O-1 context. Exceptional ability is indeed a lower standard. So let's look at the types of evidences that you can present. So for example, official academic record showing a degree or diploma that doesn't need to be an advanced degree. You can show that you have at least 10 years of full-time experience in your field. You can show that you have a license to practice in your field. You can show evidence that you have commanded a high salary in relation to others. You can show that you have a membership in a professional association in your field. And importantly, you can show that you have received recognition for your achievements and significant contributions to your industry or field by peers, government entities, professional or business organizations. And the important thing is that when you take the evidence in the totality of the evidence, they must tend to show that you are someone who actually is operating at a level that is significantly above what is ordinarily encountered in the field. Now, once you have shown that you meet the EB-2 threshold, the other challenge is to show that you actually qualify, your case actually qualifies for a national interest waiver. And it is important to consider what is being waived here. What kind of exemption are you requesting when you are applying for an NIW? Basically, it is an exemption from the ordinary requirement of labor certification. And so we can ask ourselves, what is a labor certification? Labor certification is the ordinary requirement when you are trying to qualify for employment-based green card. Ordinarily, in the EB-2 context, you need to get a job offer from a U.S. company. And the U.S. company must test the U.S. labor market to see if there is anyone else in the United States who is minimally qualified for the job who can take that position before the company is allowed to offer that position and sponsor the foreign national for a green card based on that job offer. And that requirement is there because of Congress's policy to protect the U.S. labor market. Now, when an applicant is submitting as a self-petition without a U.S. job offer, right, they are asking the government to exempt them from that requirement to test the labor market. So they must really show that their case has something more special that the government wants within the national interest that really merits the government like giving them a break from the ordinary requirement to get a US job offer and to go through the onerous, and time-consuming process to test the labor market. And you can even consider it kind of as a fast track to a green card. But in order to demonstrate that your case merits that, you do need to meet the requirements that are laid out here. And so to show that your case merits a national interest waiver, you need to meet the 3-prong matter of Danisar test, and the 3 prongs are here. The first prong is that the applicant must prove that the proposed endeavor has both substantial merit and national importance. And substantial merit and national importance, what does that mean? Let's break that down a little bit. Substantial merit and national importance can be shown in a wide variety of fields, including business, health, education, science, technology, even culture. Broad benefits to cultural enrichment can be one way you can show substantial merit and national importance. Endeavors that tend to further human knowledge in key areas such as medical advances or improvements in civil engineering technologies, for example, can qualify as endeavors of substantial merit. Now, when we speak of national importance, the important question is, what is the prospective future impact of the work that you are proposing to do? And proving that how is that important to the United States. And really, the scope and scale of the impact is very important here. So, for example, if you are a business person and you are, leading a startup project that has a very strong economic benefit that can be expected from running that company, the scale of the impact can potentially support an argument of national importance. Um, in other ways, such as endeavors that deal with developing a new drug for, the more effective resolution of certain diseases, to improve public health in a broad way, improve medical practices to save lives. That can also be another way you can show a broad impact to the public, and that can go towards showing national importance. And evidence that can support the first prong include things like expert letters from people in your industry talking about the prospective impact of your particular project, expert letters from government agencies, representatives in your government agencies or congresspeople describing what are the economic needs of a particular region and how your specific project can have a substantial impact in that priority. Those expert letters can prove very helpful towards proving the first prong. Government pronouncements and declarations in other data talking about the challenges of the nation or the challenges that the field is facing can be helpful if used in conjunction with other specific confirmations of why your particular project can have a broad impact on, solving those industry-wide problems. So substantial merit and national importance, you really need to show how your work is going to go beyond simply, helping the bottom line of one particular company or serving the interest of one employer or serving, the benefits of your immediate clients. You really need to show that your endeavor will go beyond that because the government is looking for something more, a greater impact to the industry or society or the nation as a whole. Now, the second prong for the matter of Daniels test is showing that the applicant is well positioned to advance the proposed endeavor. And here, the focus is not on the prospective project, but on the individual's unique skills and experiences. So you want to highlight your relevant education and experience, a track record of success in similar projects as to the one that you are proposing that you will do in the United States. If you have published any intellectual property in the past, past R&D projects that have been proven influential in the field, you can use those as evidences that, you will be well positioned to have a similar impact in the United States in the future. And here, I think a lot of synergy can be had with the evidences you would typically use in support of extraordinary ability petitions. If you have shown that you have made significant contributions, significant original contributions in your field of endeavor, for example, those evidences can be used towards showing that you have had this track record of success. And a history of, influential work in your field that can show that you're well positioned to continue making such an impact in your field. Any advancements towards the endeavor. So, for example, if you're, developing an innovative startup, and if you've already received interest from incubators, accelerators, venture capital funders who are interested in partnering with your company to drive forward their projects, those types of evidence of traction of your proposed endeavor can be used as evidence that you're well positioned to continue driving it forward because of the progress you have made to date. The third and final requirement to show is that on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. And to prove the third prong, there can be quite a bit of an overlap and the evidence you can pull from to make that argument. So, for example, on prong one, you can highlight the broad systemic benefits that your endeavor can have that goes beyond simply serving the interest of one company or your immediate clients. So the benefits that the government can see is greater than the typical benefits of having one worker, fill one job for one company. Similarly, with respect to prong two, if you can show that you have very unique skills that is difficult to replace with just an ordinary, worker in the United States with minimum credentials, if you can show that you have skills that cannot easily be replaced, that can help towards showing that it would be beneficial to have you, with this unique skill set to, serve your project, rather than, lose that set of unique skills. Finally, if you are an entrepreneur, there are some special considerations you can present to support the third prong. For example, if you will be developing a large-scale business project in the United States that will create a high number of jobs in, let's say, if the jobs are located in economically developing areas with a high unemployment rate. But let's say you're going to be, projecting to hire dozens of new jobs in those areas. That can be a countervailing benefit to the ordinary benefits of a labor certification program, which is to protect the labor supply. But if you are an entrepreneur who will be actually creating a high number of jobs, that can persuade the government that it will be indeed more beneficial to grant you the National Interest Waiver than to lose those countervailing benefits. All right, so now let's shift gears a little bit and consider all of the visa categories that we spoke about, and consider the importance of expert opinion letters that usually is relevant in support of all of the criteria, all of the visa categories that we've been speaking about today, including the EB-1, O-1, and NIW. So, what is included in expert opinion letters? So for these types of petitions, it is a good idea to obtain expert letters who can really contextualize the significance of your achievements. Let's say if you can have key individuals in the industry write about the significance of what you have done in the field. For the EB-1A and O-1 context, you would want the experts to confirm that you have extraordinary ability, that what you have done really sets you apart from the skills and achievements that is ordinarily encountered in the field. Similarly, you want those letters to confirm that you have sustained national and international acclaim in your field if you are trying to meet the high standard of the EB-1A. So if you can get, letters from both inner circle, network peers that you've worked in the past together, and also experts in the industry who don't know you personally, but know you through your reputation, through your work. USCIS also values those letters from independent sources as those testimonials about the significance of your work can be a little bit more objective if there is no direct professional or personal connection. So it is very important to have information about who is writing the letter. So if you're, and really the identity of the expert will depend on what purpose you are trying to serve with that letter. So for example, let's say you're trying to support the argument that you've played a critical role for a distinguished organization. In that case, you would want to have support letter from someone who is at the particular organization where that person can describe in detail what are the roles that you have played for that organization and why were these roles important for the success of the company or organization. So those types of letters would be inner circle letters where you have actually worked with those people in the past together. Now, the other type of the letter, as I mentioned, is the independent expert type letter where independent professionals would know you through your, your reputation and your work and the significance of your work and can provide independent objective assessment of the significance of those achievements. Now, with regards to the content of the letters, it is very important to have the requisite level of specificity. And sometimes we would see drafts of letters where you would see a lot of superlative adjectives saying that, confirming that what this person has done is indeed extraordinary, but not providing enough detail about exactly what the person has done and why these types of achievements set them apart from others in the industry. So why was it a significant contribution to the field as a whole? What was the industry-wide limitation or problem that the person's work solved in a major way. So these types of concrete details really is helpful to have the expert letters describe in sufficient detail because those types of narratives really, bring the petition alive for the USCIS adjudicator. So it is very important to have the requisite level of concrete detail, conclusory statements, and simply restating the regulatory language would not be helpful uh, uh, in terms of probative value. All right. So now let's talk a little bit about some other strategic considerations when you are considering which category you should apply for. What are some of the considerations um, that you can consider? So the first question is, do you want to stay in the United States temporarily or permanently? And as we mentioned in previous slides, the O-1 visa is a non-immigrant visa that is well suited for temporary work arrangements in the United States. Um, and the EB-1A and NIW are both green card pathways. So for people who want to live and work in the United States permanently, and maybe this can also open up a pathway to citizenship in the future. If that is in your long-term plans, you can consider applying for the EB-1A and NIW. The other question to ask is, do you have a U.S. employer or agent who can apply for the petition on your behalf, or do you want or need to self-petition? So as we briefly mentioned before, the O-1 visa categories do require a U.S. employer or U.S. agent to file the petition. Now, one thing to note here is that it is possible for an entrepreneur to set up their own company in the United States and have that U.S. company be the U.S. Petitioner to drive forward an O-1 petition. So it is possible for you to have ownership over a U.S. company. Now, when you're using that kind of arrangement, it is definitely important to get in touch with an experienced lawyer to discuss the nuances of that, because you also need to provide a bona fide evidence of work in the United States that exists in your field of extraordinary ability. So in those scenarios where an entrepreneur is setting up a startup and having that startup be, the petitioner for the O-1 visa, we would also have supporting evidence of the work that is existing for that startup. So third-party contracts with, other companies that seek to hire the startup for services or products, those types of evidence of traction is usually very important to show that it is indeed a bona fide job offer. With regards to the EB-1A and NIW, as we mentioned before, both green card categories allow self-petitioning. So a job offer is not required. The foreign national themselves can drive forward the petition. For the EB-1A, you do need to also provide a statement of intent of future work. So you do need to show that you do have the intent um, and a plan to continue working in your area of extraordinary ability in the United States. And for the EB-2NIW, it is very important to have a plausible proposed endeavor in the United States. And in many, many cases, it shouldn't just be a paper plan, right? So the more evidence of traction that you have, the more evidence of interest from relevant U.S. Agencies or individuals who are interested in partnering with you in that project, the better it will be for your case, because that will, also show that you're well positioned to advance your endeavor and also make your proposed endeavor more plausible. However, it is important to note that you do not require a separate U.S. petitioner other than yourself to drive forward the petition. All right, so the final question that you can ask is what are some family needs with regards to the visa? As we mentioned before, for the O-1 visa, your spouse and minor children under 21 can come to the United States with you on the O-3 dependent visa. And it is possible for the O-3 spouse and children to study in the United States, but unfortunately, work authorization is not available for O3 dependents. By contrast, the EB-1A and NIW both are green card options, and once you apply for the green card, um, your spouse and minor children under 21 can also qualify for derivative green cards as dependents and also be eligible for the similar benefits of work and travel authorization if you choose to proceed by filing an I-485 adjustment of status from within the United States. And spouses and children can also apply for those same benefits. All right, so other strategic considerations if you are in a non-immigrant visa when you are planning to move to a green card. So the first element to keep note of are the standards for qualifications, which can differ between the non-immigrant option and the immigrant option. And it is important to note that there is a higher standard practically to qualify for the EB-1A with the two-step Khazarian analysis, which is very stringent, as opposed to the O-1A and O-1B, which can be a little easier. And especially if you're trying to go from an O-1B to an EB-1A, the jump can be particularly a higher jump. So definitely it is important to note that qualifying for an O-1A or O-1B visa does not mean that you would automatically qualify for an EB-1A as well. Um, Another element to note is timing. So very important to consider how much time is left on your current underlying visa while you're considering applying for an immigrant petition, because some visas are harder to extend or can be subject to more scrutiny after an I-140 green card petition is filed. One example of that is the TN visa. Once you have filed an I-140, for example, and you try to, go to the border to renew a TN visa, you may get, more questioning from the officer with regards to your non-immigrant intent. There are particular types of visa categories that really look at non-immigrant intent quite strictly. Other visa categories, such as the H-1B or the L, are dual intent visas, and you would be fine even if you have an I-140 filed, but other visas may be more affected. So definitely that is something to discuss with your attorney. If you have the plan to file an I-140, maybe there is uh, a good way to time those applications that reduces such risks. Finally, family considerations can be one reason why you may want to, apply for the I-140 early. If you have children who may also need the green card, the child will be aging out at 21. So it is very important to plan ahead and file for the immigrant petition early enough to avoid potential issues with aging out, because that will mean that the child will no longer be eligible to obtain the green card as a derivative. All right, so the final question to go over here is, are extraordinary ability categories available for entrepreneurs? And the answer to this question is yes. And here are some of the reasons why it can be a good option. The first reason is that the EB-1A and EB-2 NIW are both green card pathways that allow for self-petitions, meaning both are possible options for entrepreneurs. You do not need to have a third-party U.S. company to sponsor your petition because those categories allow for self-petitioning. You, as a foreign national, can drive forward the case without needing a U.S. job offer. The changes in the NIW standard under matter of Denizar, which is an AAO case that was selected as a precedent since 2017, made NIW a much more friendlier category for entrepreneurs. And the NIW, the new NIW eligibility criteria, even, in the third prong, for example, even talks about the fact that the traditional method of labor certification may not practically be accessible to entrepreneurs. And Matter of Daniels actually specifically mentions that NIW can be a good option for entrepreneurs. So you can definitely consider applying through the EB-2 NIW. One thing to note, though, is that changing adjudication climates regarding national importance is indeed making it a little bit harder for entrepreneurs who may not be able to show a broader impact to the industry or field beyond helping one's own clients or, producing a more localized profit or economic impact. The scale of impact that must be shown is definitely something to consider importantly when you're considering this green card pathway. Finally, it is possible to apply for an O-1 visa as an entrepreneur. If there is a separate corporate entity, a U.S. entity that can serve as the petitioner. Again, this is a nuanced area, and there must be some other evidence that you can rely on to show evidence of, a bona fide job offer and work that is existing in your area of extraordinary ability. So definitely be in touch with us if you'd like to discuss your case in further detail. All right, so now we have about a couple of minutes left. Let's maybe go through if there has been some questions. Here, I just see one question that came in on the Q&A function. It looks like the question is about if you have an EB-2 petition approved, and if you have an EAD, can I work under the EAD even if you were originally under a student visa status? Now, one thing to note with regards to questions like this is that there are two steps to applying for a green card, and the first step is filing the I-140. And the second step is if you have maintained your underlying non-immigrant status, you can apply to adjust status to a green card holder by filing an I-45. Now, step one and step two are two different steps. You do need to have the I-140 approval in order to be able to file the I-45. But unfortunately, the I-140 approval, basically, having been approved for eligibility, with the, for the NIW through the approval of the I-140, that in itself does not provide any independent status. You also need to have maintained your underlying status up to the point where your priority dates will be current, such that you can apply for the I-45. Now, if the particular person wants to discuss the particular circumstances in more detail, a consultation is the best way to do this. So definitely reach out to us using the consultation link that we will be sending. But in general, it is important to note that filing and having the I-140 approved does not confer any independent underlying status in the United States. So you must continue to be eligible, continue to meet all eligibility criteria of your underlying non-immigrant status in order to qualify for to file an I-45. So that is definitely a good distinction to keep in mind of. Okay, so I don't think there have been any other questions that came in. So thank you everyone for your participation, and thank you, Katie, for sharing your insights. And I hope everyone has a great day and see you at the next webinar.